YouTube, this is VidHead85 here, and I'm going to talk a little bit about the DOMA and the Prop 8 here. Now, DOMA was passed into law because in 1993, Bayer versus Levin was going to say, hey, gay couples can marry. The Congress in 1996 said, no way, marriage is between a man and a woman, and the states can choose whether they want to do that. But federal government, for the benefit of federal government and our heterosexual superiority, we will recognize marriage as only a man and a woman. Proposition 8 goes back to Proposition 22, called the Knight Initiative in 2000, which was 62 to 38 in favor of saying that marriage in the state of California that will be legally recognized is between a man and a woman. Now, in May of 2008, the California Supreme Court said, nope, that is unconstitutional. And while the case was still pending before the California Supreme Court, the opponents of marriage said if there is a favorable ruling, even if there is not a favorable ruling, we will put Proposition 8 in our Constitution. At the time, it had not yet been assigned, or it may have been assigned Proposition 8, but it qualified for the ballot shortly, a little while before the May ruling. So now that Proposition 8 is dead, let's go for that one. Now, Proposition 8 was challenged in state court in Strauss versus Horton. They found it constitutional, I believe, on a technicality that it was not a revision but an amendment, and it was upheld on technical grounds as far as I know. I could be wrong. If there's anyone who knows a little more about the Strauss versus Horton case, please leave it in the comments, and I will definitely put them in the About section. But anyway, Proposition 8 was upheld at the state level. January 2010, that is when we had the 12-day trial. Judge Vaughn Walker struck it down in ringing terms, sounding a blow through to every anti-gay individual who would want to bring a case. Now, in August 4th, 2010 was when that ruling was put out. They appealed it to the Ninth Circuit Court. The Ninth Circuit Court said, well, what about, hey, these proponents? Wait a minute. When the governor and the attorney general don't defend a ruling, can they do it? Hey, California Supreme Court, hey, do they have standing? Let me see. We'll have to schedule a hearing we'll schedule a hearing and get back to you in 90 days. All right. So 90 days later, hey, yeah, Ninth Circuit Court, these proponents have standing in state court to do this. So then the Ninth Circuit Court in February 2011 says, hey, yeah, Proposition 8 is unconstitutional. Perry versus Brown it was at this time. And you can still get the ruling. I will definitely save the ruling because it is a wonderful thing that compares Proposition 8, which was in regard to marriage, to Amendment 2 in Colorado in 1992. That is the Romer versus Evans case. So now the Ninth Circuit Court talks not only says that they have standing, but now what we're going to do is we're going to rule on this and it's unconstitutional. They appeal to the Supreme Court, but not before they can try to get Judge Ware to vacate Judge Vaughn Walker's ruling that was handed down in August 2010. Judge Ware says, I will not vacate the ruling, and he rules on the tapes as well as the, only after, before it got to the Ninth Circuit Court, it went to Judge Ware regarding the recordings, and they consolidated that with the Ninth Circuit, saying, we want to keep the tapes under wraps. They said, okay, you can do that. So now it gets to the Supreme Court, where they basically said, well, you know what? The state court said that they can go ahead and they can defend this law, but the federal courts have never really recognized that. Now, the Supreme Court chided the Ninth Circuit for not certifying the question to the state court, but they were looking for an easy way out, and that was a procedural method, which I am happy with the result, but not with exactly how it ended. But it didn't end with a constitutional question. But either way, Proposition 8 had ended on a technicality because of the fact that the federal court will not grant the standing, and it must prove harm. Diamond versus Charles is a California case that was given precedent, or that is precedent for standing cases. So Proposition 8 is dead. We have more work to do. We have Amendment 1 in North Carolina. We have Amendment 3 in Utah. Sanctity of Marriage Amendment in Alabama. We have so many other places to go, but right now we will we will be thankful for this victory. But the next thing we have to do after all of this is protect the rights of voters. And if anything, I think that Congress should pass a Voters' Bill of Rights, which basically is the Voter Rights Act. And I think that that's definitely next on the agenda. We will see a lot of momentum in state courts and in state. We will see a lot of things happening. And hopefully against those prejudice laws, we will see injunctions. But that is how Prop 8 ended. DOMA was pretty much open and shut because the people who did intervene did have standing. The House of Representatives, whenever the president refuses to defend a law, it goes right to the House. And Ronald Reagan, George W. Bush, Woodrow Wilson, Bush the first, Bush the second, Clinton, Carter, all of them have, prior to Obama, refused to defend a law, and many times they have sided with the president, they have not sided with the president, the Supreme Court, and that is not unprecedented, as many of the T-Publicans would have you think. So, Prop 8, DOMA, my thoughts, the procedural history of Prop 8 is a little more involved than DOMA. But, ding dong, they're dead. Now let's move to voter rights. Have a good day.